recommend, we had skipped that one, but I would recommend we do that one.
Okay, Jonathan, you tell us, what number are we going to next? You tell me.
36, Tinney. So this is the same issue, where the petition sheet did not list, it listed a non-incumbent position when it's in fact an incumbent position.
36, right?
Yes.
And are you Mr. Tinney?
I am.
Okay, Mr. Tinney. For the record, spell your name for our court recorder here.
First name is Michael, Michael. Last name Tinney.
Okay. And Jonathan, just to get us up to speed, is it the same type of thing? There was nobody there and an appointment was made?
I think on this one, it wasn't an appointment. I think it was always an incumbent, or is that not correct?
There was an appointment.
There was an appointment. I'm sorry. So it was the same issue where the petitions that we're recommending disqualify, which in this case are all of them, were circulated after the position was filled. So it was an incumbent position as of the date that these petitions were signed, and the petition indicates it as a non-incumbent position.
When did the position get appointed? Is that the 7th? Is that what I'm reading in here, or what was the date?
I believe it was January 7th, 2022 is the date that the position became an incumbent position.
Thank you, Director Berger.
Okay, Mr. Tinney, tell us, you've listened to the last
Yes,
round
sir.
of testimony. How does your petition differ?
Thank you. So in a combination of door knocking and meetings set up by others, I collected near 300 signatures from the citizens of Taylor. When I was beginning to collect signatures, I visited the state of Michigan's pertinent websites regarding this, and every section that pertained to my potential candidacy was marked as non-incumbent candidate. For this reason, my petitions were then titled as non-incumbent. It was an honest, albeit, and in my opinion, reasonable belief that the heading was correct. However, there is, as stated in the previous, there's no reason to distinguish, as there is only one other person up for election this year. This is not multiple judicial positions within the 23rd District Court. And therefore, it's, as was stated previously, apparently is not statutorily required for the incumbent or non-incumbent to be listed on there. However, in my elevator pitch, I had explained that Judge Salamone had retired in November of, or the day before the November 2022 election, or 21 election, and a appointee was appointed therefore afterwards. And Governor Whitmer had appointed that place after the election. Because of this, there would have been a special election this fall, and I've attempted to collect enough signatures to get on the ballot for the primary in August. I then reviewed each petition sheet prior to submitting them. Given the fact that there was a sitting judge that had been appointed, I honestly, albeit incorrectly, believe that they titled correctly as I was the non-incumbent candidate, and therefore filed the petition sheets on April 15. When I turned my petitions in on April 15, the staffer who accepted petitions and affidavits did not make any mention of the error in the titling of either. Had I been notified then, I have no doubt I would have spent the weekend and canvassed Taylor voters and attempted to cure the issue by getting at least 200 signatures with the correct title. It was not until Amy Lovegrove from the Bureau of Elections contacted me around noon via email on April 19 was I first alerted to any possible issue. I was allowed to correct the affidavits, but was obviously not allowed to correct the petitions. A written challenge was filed April 25. A copy was not provided to me until nearly 2:30 p.m. on May 3rd, with a response required to be entered by May 6th. If not for the constant efforts of an attorney to attempt to get a copy of the challenge, I cannot guarantee that I would even have been served with a copy to respond to, even seeing what the merits of the challenge was, even though the Bureau had been able to contact me via email less than 2 weeks prior. With only 2 days' time, after a full day of work each day, I was able to door knock and meet over 100 citizens who had previously signed my petitions with a notary to have them sign affidavits to the fact that the situation was explained to them, that they were not misled, and that they knew that there was a sitting judge that I was trying to run against. If I knew I could have brought more and handed things out to you today, I would no doubt have contacted the other and try to get it all
How
near.
many did you contact?
I turned in 104 affidavits.
Wow.
That was in 2 days. Again, after work, so between basically the daylight hours that I had left after work.
And why did you put down non-incumbent again? What were you thinking?
Because every time that I visited the state of Michigan's website regarding my potential candidacy, every link that you click, it's separated between incumbent candidates and non-incumbent candidates. So I had to always access the areas that were the non-incumbent candidates. So that's in my, albeit incorrect assumption, was that because everything that I had to click was non-incumbent, I included that on my petitions to inform the voters that I was not the incumbent, but that I was in fact challenging the sitting judge. And then, and again, going back to the point where I turned in 104 petitions, using that trajectory, had I been given notice on April 15 that there was a titling error, and I would have had the entire weekend plus 2 other days to collect signatures, I have no doubt I would have been able to, again, clear the 200 hurdle with the correct title. My response was entered on May 6th. However, the eventual staff report generated by the Bureau of Elections was also not sent to me, as others had theirs done. Rather, I had to hunt for it, and again, somehow the Bureau seemed unable to email me, though I have received communications regarding campaign finance in the interim via email. And in fact, within the last 2 hours, I just received another one to my campaign email regarding candidate training, or candidate committee training. So they have my email on staff, or on file, but they have been unable to send me the challenge and the staff report within any, in my estimation, reasonable time. So due to the lack of confusion and the fact that the signatories were not misled, the issue is clear that the 3 letters in the front of the word should not invalidate the entirety of the signatures presented. If there are multiple positions up for election this year in the 23rd District Court, the argument that would hold more water. But there was only one position up for the election in this cycle, and the voters were explained the dynamics of my candidacy. Additionally, the Bureau of Elections itself was able to identify the specific race that I was running for when one of its own officials, Amy Lovegrove, flagged the issue and contacted me, albeit 4 hours before the deadline. Clearly, there was no confusion on the part of the Bureau of Elections. For the Bureau to say that in the most recent staff reports that one type of incorrect heading or an expiration date was incorrectly written, and there was an allegation of fraud in that person's in their staff report, and also another where there's listed 2 cities, that those are allowable as harmless error, and then to turn around and say in a different race that an analogous error is fatal, is arbitrary and capricious, flies in the face of common sense and fundamental fairness. As was stated before, your mandate is to canvass and confirm the requisite numbers of signatures. That has been done in my case. There was no allegations of forged signatures or that they were obtained by fraud. Looking at the totality of the circumstances surrounding the issue, no signers were misled. The Bureau of Elections clearly knew which race the petitions were intended for, and the lack of procedural due process and even informing me what the substance of the challenge was, and the fact that there is not a necessity for a distinction in this case, I ask you to reject for the Bureau's recommendation and instead find the petitions were valid, and therefore the 300 signatures that were collected, or near 300 signatures, well in excess of the 200 needed, make me a valid candidate among the people of Taylor to determine who the next judge should be in November and not to disenfranchise them.
Okay, Michael. You're working hard at this, and you're running against, you want to run against somebody who's never run before, appointed.
That is correct.
So, in effect, you're running against an appointed incumbent, not an elected incumbent.
That is correct, sir.
But still an incumbent by the definitions we use. And we just went through this on the previous case, so I think I know what we're going to end up doing, but I'm sympathetic with you. And you're working very hard, especially getting 100 affidavits. Give me a break. That's hard work. So anyway, any questions to the witness?
Yeah, you knew the person who was appointed to the position was appointed before you started circulating, right?
That is correct, ma'am.
So you knew that person was the incumbent.
I knew that they were the
You knew
incumbent.
that person was the incumbent, but you designated it a non-incumbent position because you were not the incumbent.
That is correct. I didn't want to mislead the voters into thinking that I was the appointed judge. I wanted them to know
So
that I was.
You misunderstood the designation that you were supposed to be making.
Yes, ma'am.
Yeah.
Any further questions? Thanks for coming in.
Thank you, sir.
I will excuse you. Okay, board, what do you want to do here?
This is just another one of these brutal calls where this gentleman is working so hard what he thought was, but we're bound and tied on the fact that this was incorrect. So I move that the board accept the staff recommendation, find the nominating petition filed by Michael Tinney insufficient.
Support.
Moved and supported. Is further discussion on the motion? Seeing none. Adam, please call the roll.
Mr. Chair,
Yes.
Madam Vice Chair,
Yes.
Member Dawn,
Yes.
Member Bradshaw,
Yes.
The motion passes. I'm going to run the 38 and 39. Is that okay? Jonathan?
Going back to 14?